Be seated. Good morning. Now is the time set for oral argument in cause number CACV 150511, Elizabeth Ashby versus Alexis Karen Bigelow, B-I-G-L-O-W. For everybody's information, these proceedings are being both audio and video recorded, so barring any unforeseen problems, as I'm sure you are by now aware, you get to be on YouTube in a couple of weeks. Counsel, each side will be entitled to 20 minutes, no surprise there, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. An appellant, as I'm sure you are aware, if you wish to reserve any portion of your 20 minutes for rebuttal, you probably want to let us know that ahead of time so we can avoid taking up all of it. However, ultimately, your reserving of rebuttal time, will be up to you. We have reviewed the briefs and conferenced the case, so we are well aware of the facts and issues attendant to this argument. We say that so that you can figure out how you want to best use your time here this morning. Counsel, when you come to the podium, I would ask that each of you state your name and who you represent. And with that, the appellant may begin.
Good morning, Your Honors. Neil Thomas and Kristen Briney on behalf of Appellant Bigelow from the law firm of Thomas Marks and Rubin and Kelly. Let me begin first with, here we are talking about sort of a quagmire of our rules where, for whatever reasons, justifiable or unjustifiable, we're mired in an arbitration system in which the courts say, because of a certain amount of money, we don't need to go to court. We're going to do this through the court-appointed system. Sometimes issues get lost, and sometimes issues get raised, and sometimes issues spring, but they often don't make it here because it starts at the appellate court level. And this is kind of on the verge of that. And I'd like to remind the court that recently, after we briefed these cases, the court decided the Southwest Barricades versus Traffic Management case. That case has nothing to do with this case other than there's a lengthy footnote 3 that raises the exact issue before you on how you deal with the infirmities of problems that arise with the appeal from arbitration system. And now I'd like to give you a little sketch on the background or the framework. It's sort of an interesting anomaly, if you permit me. First, you go to the arbitration system. Second, you get a notice of decision. Third, if you do nothing, which didn't happen here, if you do nothing, it becomes an award by operation of law after 50 days. Fourth, if you do nothing, after 20 days, your notice of appeal has now, without any notice, anything from the court, has now run. However, if the plaintiff or the prevailing party doesn't say, award, I want you to be a judgment to the trial court, it ultimately gets dismissed. But there's a key issue there. It says we'll dismiss the case, but we're only going to give you notice. So in order to kick the case out of court all the way at the very end of the process, whoever might have wanted to get it reduced to a judgment and collect on the award now has had the requirement and gotten the opportunity of written notice that something happening. So it could be from day one until 30 days after the time is run is the first time the court ever sounds in, because it all happens automatically under these rules. The Southwest Management case says we need to deal with what happens with some of the infirmities of what I would really call post-trial motions. We know about motions for new trial, motions to amend judgment, and all the time-staying things that exist in the rules of civil procedure and the rules of civil appellate procedure.
I understand you have disagreement with the rules, but let's focus here on this case. You received a notice of the decision of the arbiter in this case.
Absolutely.
And you also knew under the rules that that was going to be automatically convert to a judgment within 50 days.
Yes. And I understand under the rules you would know that. Unfortunately, we have the injecting of what I got to right at that point. What would be post-trial motions? In this case, for some probably strategic reason, the plaintiffs filed their motion to remit the arbitration award. As the discussion ensues in the paperwork with the arbitrator, it was probably to give them a better chance for a more favorable result on appeal by lowering the percentage for sanctions. Whether that was an intentional or a negligent strategic decision to move the matter along in a different way, in a different manner, who knows? But the arbitrator, what did the arbitrator do? The arbitrator didn't ignore it. We didn't ignore it. We responded to it. The arbitrator sat on it for a while and then ultimately decided that wasn't going to do anything and will file the award in writing. Will file the award. Guess what never happens? The award we're waiting for doesn't get filed. It becomes automatic because of the notice decision that was already persuaded.
Let me ask you a question on that point. And forgive me, then I want you to go back to Judge McMurtry's question. I was looking at the index of the record on appeal, and the notice of the arbitrator was filed on March 31, and then there is a joint report on April 1. Was the motion for remitter that you're mentioning, is that the joint report?
No, the motion for remitter is attached to our response to the application for entry of judgment, because the motion for remitter is filed with the arbitrator. And you're right, that's another fact that shows up. The day after the award, there's already discussion. The parties are filing a joint report saying when this matter will be ready for trial in about a year. So this isn't just a case where notice decision springs into an arbitration award and then doesn't get appealed from. This is a case that's being actively litigated. And perhaps the most telling sort of innuendo that I would, if I wanted to cast disparagement, and I'm not intending to do that, is right after Mr. Rubin says, what are we doing with this because we haven't heard from the arbitrator by filing the award, plaintiff sits down and realizes that the 50 days has run and wants a judgment. The trial court says, yeah, your notice of appeal is untimely, which is what the Southwest Management case comes up with, is what happens when you want to delay an appeal of arbitration. And who does it, the trial court or the arbitrator?
Counsel, is there a rule, and I know that they're changing so quickly these days that it's hard to tell if there was
Happened
yesterday,
again
but may not
January
be
1.
tomorrow. Is there a rule that suggests that coming out of arbitration there are time extending motions that will otherwise defer the 50 days or offset the entry of the award following the notice of decision? Or is that rule clear and specific that 50 days from the filing of the notice of decision, the notice of decision becomes an award if an award is not otherwise filed?
There's no specific framework for what happens after the notice of decision and no other activity. There are no rules. The DeCola case went to the Rule 77 discussion about the notice that the court gives on minute entries, and it also says that it doesn't delay time. But the DeCola case said yet there ought to be a remedy for what happens with something like this. We're in that bailiwick, and what did we do? We used a rule, a motion for enlargement of time. There's no rule that says that the Superior Court can't enlarge the time, and there's no rule that says it must enlarge the time. Obviously, it's a discretionary decision, but we have no basis to know what the discretionary decision was made by the trial court for either the enlargement of time motion or the follow-up 60C motion, both of which are mentioned as possible issues this court needs to discuss in some level, but hasn't done, and says we're not doing advisory opinions in the Southwest Management case that came out after this matter was briefed. So I would refer you to that footnote if you're not already aware of it. I would think you might be, but it's one of the longer footnotes I've ever seen that discusses the pitfalls that we sit in. We've raised the constitutional argument, we've raised the Rule 60 argument.
You raised it here, but you didn't argue it to Judge Udall below, correct?
Correct. We've raised the procedural arguments. This court clearly has the authority under DeCola to fashion what necessary relief is appropriate for this kind of a quagmire, and it is a quagmire. I'm not sure why there isn't a time-staying motion or a time-staying rule or a non-time-staying rule. It's silent. And the biggest faux pas, if you want to call it here, is we're waiting for the award. The arbitrator says they're going to enter. It's not like it's going to
convert. Anything that would have
convert.
prevented you from filing a notice of appeal, even though the judgment had not been filed by the arbitrator, and then just ask the trial court to stay the proceedings till the arbitrator rule on those?
We filed the notice of appeal. It was struck.
When did you file it?
2 days after the application for entry of judgment.
No, I mean prior to that, when it would have been timely.
No, there's nothing that would have prevented it, but it would have, in our view, it would have been premature. The Cola case talks about you don't want to encourage premature appeals because, in our view, we're still waiting on an award. It's the award that triggers the 20-day appeal.
Well, except
It's
you
the
already-
rule that makes it automatic.
You already knew that there was a notice of decision, and you already knew that the arbitrator was not inclined to change that decision, correct?
The day the arbitrator said they were not inclined to change the decision, that he said she said she will file the reward.
Okay, so the answer to my question is yes, you did know that the arbitrator was not inclined to change the decision.
Yes.
So there was nothing at that point in time that would have prevented you from filing a notice of appeal, knowing that you were not going to get any relief from the arbitrator.
Well, during that period of time, there was ongoing activity and motion work, there was ongoing activity with the plaintiff on what was to go forward. We were waiting willfully, innocently, incompetently. We're waiting on an award, and our lawyer, Mr. Rubin, says, what are we doing with this? And 2 days later, the application for entry of judgment comes in while there's been ongoing discussions. Now, what we're really talking about is, by the strict reading of the law, yeah, there's a rule that says how you do the strict reading rule. It doesn't say it's jurisdictional, doesn't say whether it should or shouldn't be exchanged. The COLA makes it real clear, as to all the cases, Rogers versus Watt, Park versus Strick, that the concept of delayed appeals is not an ironclad rule. The COLA speaks, as we often want to hear, one of the basic things, we want a trial on the merits. There's been no trial on the merits. There's been an arbitration, and there's not been a jury trial. There's not been a right to a jury trial. And in our wisdom, we've decided on small cases, if you want a jury trial, you have potential sanctions after you go through the arbitration process, not an ironclad standstill rule. We're talking about equity, and we're talking about justice, and we're talking about fair notice. Yet, there's notice when you get farther in the process, but there's no notice when you get earlier in the process. And I concede, except for the bare existence of the rule. And I will tell you that
What more notice can you have? The minute the notice of decision is filed, you know that within 50 days, if nothing else happens, that becomes the judgment.
But for the conduct that gets enforced. You're right, you can read the rule that way.
But for what conduct?
But for the fact that there was still litigation and an arbitrator that still has jurisdiction, because the arbitrator is not deprived of jurisdiction until the notice of award is filed. That's the exact quote from DeCola. Well, the arbitrator's never been deprived of jurisdiction, but we decided, well, we're going to go to the Superior Court,
Doesn't
not
the
the arbitrator.
conversion, the automatic conversion, then become the judgment, thus
Absolutely.
removing jurisdiction from the arbitrator?
I would say that the fair reading would be, if you're going to be strict, that the 50-day removes the jurisdiction after 50 days. And there's no rule that deals with what happens if the arbitrator is still talking about attorney's fees. We're still doing something.
I think there is the rule. If the arbitrator is still talking, but nothing's happened, 50 days it converts.
That's what the rule says,
right.
and the plaintiff's brief is all about there's a rule, there's a rule, there's a rule. Well, all of the cases that have dealt with 60C6 relief, 60C1 relief, delayed appeal from arbitrations, could all have said there's a rule. In this case,
Isn't the real problem here is that there's a 50-day window to take care of all these matters with some degree of expeditious diligence to tie up all of these matters. And thus, if they're not tied down and finished up, at 50 days, it just converts and goes forward.
that's exactly the strict right. If you folks are inclined to say, there's a rule, we read it, we're done, I lose.
Okay.
Okay?
So,
I concede.
And I know this is harsh, and we're not trying to pick on you.
You should. That's your job.
No, it's not really. So we have these rules. So if I was going to try and write a decision here that could assist you, what am I going to write in light of these rules?
Under the facts and circumstances, the trial court abuses discretion by not allowing a 3-day delayed appeal.
But does the I'm sorry, forgive me.
Go ahead.
Where do I then get the citation of authority to support that point, that the trial court has discretion to allow a 3-day extension? Where would I look for that?
Well, you could look for guidance to the footnote in the most recent case about how it's still sitting there, number one. Number two, you can look to the 60C rules. Number three, you can look to the Rule 6 enlargement of time rules, which is addressed in that footnote as well. And all of those support it, but where you really look is back to when the court decided what 60C6 and 60C1 are, when they said, well, we used to be real strict, notice of appeals, notice of appeal, and they started the Geiler case, the Webb versus Erickson case. It's the same discussion. Even the DeCola case says there has to be a remedy for this because in that case they didn't get notice of the notice of decision. So, well, since they didn't know there was no notice of decision, they didn't know when to start the 50 days. Well, someone could look at the court docket and they could have said, oh, wow, the notice of decision was filed, the 50 days ran. You had 50 days to wind up all these affairs if you had looked at the court docket, even though you never got the notice from the arbitrator. Here, we have the arbitrator willfully mired in the quagmire.
That's not this case in the sense that you did. That's why I asked the question, did you get notice? My question to be, where's the excusable neglect in this case?
Well, first off, I'm going to say the excusable neglect is not necessary under the motion of large time. The second level is the excusable neglect is the confusion engendered by the arbitrator and the lack of any rule that clearly addresses how we're supposed to deal with this scenario. And I think you can now say, if this were today, you'd really be in a quagmire after you look at the footnote in Southwest Management that says, we really don't have it. I would, by analogy, as the court has often done, by analogy, look to the rules farther along in the system on the more important cases, the cases that never see arbitrators, where the rules have been given a sense of equity and justice and lived by the not too overused scenario of we want trials on the merits, which never happened. And I'll take the rest of my time for rebuttal unless you have more questions.
No, thank you, counsel.
Good morning, Your Honors. My name is Nate Cooley, and I am representing the plaintiff, Elizabeth Ashby, in this case. A couple of things I want to address right off the top. As I read through the briefs, appellant's opening brief and the reply brief, there's a lot of, it feels like, legal gymnastics, jumping over hurdles, jumping through hoops to get to the point to say, well, the only thing that matters in this case is whether or not notice was received. And I think when you get down to the issue, that's really the only question in this case, is Rule 76B at the time, which is now Rule 76C, adequate notice that the notice of decision will convert to an arbitration award after 50 days. And if the answer to that question is yes, their case completely falls apart, because their citation to Rule 9A of the appellate rules and Rule 6 in the Rules of Civil Procedure, which is talked about in the DeCola case and also the, I have a hard time pronouncing this one, but the Haratunian case, basically says that application of Rule 6 and Rule 9 of the appellate rules is premised on the aggrieved party not having received notice of a final judgment or final order. And that's their argument in this case, is Rule 76B, this automatic conversion of a notice of decision to an arbitration award, is not adequate notice. And if that's the case, then they can get to this argument that well, it's within this timeline that we're filing this motion for an extension of time, so on and so forth, and no party would be prejudiced. However, our argument is very simple. The provision in Rule 76B that converts the notice of decision to an arbitration award after 50 days is clear. They missed the deadline, the 20 days started to run, and they missed their timeline for appeal.
But isn't the confusion in this case the fact the arbitrator specifically told both parties that she was going to file a judgment?
I believe that's their confusion. I wasn't confused about that.
Did you anticipate her filing it? Did you anticipate her filing a judgment?
She said in her email to us that she was going to stick with her decision. Well, let me go back in time a little bit.
It's really nice if you answer the question.
Okay,
first,
I'm sorry.
And then explain yourself.
Okay, so she said in her
No, did you anticipate her filing a judgment?
Yes, I did. But
So
she
both parties believed that a judgment was going to be filed.
yes, she said in her email that she will file an award, but she never did.
Okay.
So going back, she filed a notice of decision, and as the rules state, any parties allowed to submit a proposed form of award, which is what we did. We didn't file a motion for remitter or anything like that. I sent a cover letter to the arbitrator and copied defense counsel and said, here's our proposed form of award, which, by the way, is less than your notice of decision, and this is the reason why I'm doing it. And that was pursuant to the arbitration rules. They had an opportunity to file an objection, which they did. I filed a reply. The arbitrator took that under advisement, and she sent her email, said, I was hoping the parties would come to an agreement, but I've decided to stick with my decision. I will file an award. This was before the 50 days had lapsed. So
How much in advance, forgive me, I should remember this, how far in advance of the 50 days, roughly?
when she sent her email, said she's
By
sticking with her
email?
decision.
I mean, it wasn't like on day 49.
No, it was May 14th when she sent her email, and the arbitration, or the notice of decision became the award by operation of the rule.
On the 21st. So
A
about
week later.
Okay, so then, keep going.
And so here I am sitting here, okay, she's going to file an award. She doesn't file an award. So knowing the rule, after the 50 days are up, on day 51, the notice of decision becomes an award. And I'm wondering, okay, is defense going to file an appeal? And keeping in mind, it's not my obligation to advise them of the rules. Whether they file an appeal or not, that's up to them. I've had numerous cases where defense attorneys or their insurers or whatever threaten, hey, we're going to file an appeal after this arbitration. Sometimes it never comes. I didn't know if they were going to file an appeal. So at some point after...
Well, I'd like to follow up on a question that Judge Norris asked earlier, and that is, could the arbitrator have issued an award after the 50 days ran?
No, because by operation of Rule 76B, the notice of decision becomes an award on day 51, and she's divested of jurisdiction according to the Riggs case, or the Driggs case. Mm-hmm. So she didn't have any jurisdiction at that point.
But for the language of this rule, but for the 50-day conversion from a notice of decision to an award, and I believe this goes back for some people with gray hair here to the days before this was the language of that rule.
Or in your case, no hair. I can see the back behind you.
What? Much is said about the fact that the arbitrator had promised this award, right? I'm going to do it. I'm going to file an award.
Yes.
What would happen if it was not for that language? What would the process have been otherwise then? If it was not for the language about the 50 days? The 50 days serves a purpose, right?
Yes, we would still be in limbo because an award would never have been filed. And that was my argument in my brief, is that if her promise to file an award abrogated the 50-day window in Rule 76B, God forbid if this arbitrator died, where would we be? She would never have filed an award. What if she disappeared? There would be no award. That's why the provision in Rule 76B, the automatic conversion of a decision to an award, is important, because for whatever reason, it was added, I assume, because it was routine that arbitrators would file notices of decisions but would fail to file awards.
Good presumption.
I'm going to address a few things they brought up in their argument. The first thing he said is he talked about that we filed a motion to remit the award, and I think I already mentioned this, but it wasn't a motion to remit the award. It was a proposed form of award under the rule. That's why it didn't go to the court. It was sent directly to the arbitrator. There was discussion or mention of the joint report that was filed. The reason I filed or worked with Attorney Rubin to file the joint report after the arbitration was because that was what the rules required. and I was trying to be in strict compliance with the rules and the timelines. After we filed the joint report, the court issued a minute entry saying the joint report wasn't necessary. So
it wasn't a remittitor, it was a proposed form of award. And after that, the arbitrator said, I'm going to stick with what I've got.
that's correct. It wasn't a remittitor in the sense of a Rule 58 or whatever, I believe. It was a remittitor in the sense that this proposed form, the amount requested in this proposed form of award is less than what you stated in your notice of decision, which again was a strategic decision on our part, trying to dissuade an appeal to make it more difficult for them to reach that 23% threshold if the case was to go to trial.
Okay, so if there was not a motion for remittitor out there, and what had been filed was in fact a
Proposed form of award.
form of award, and the arbitrator said, no, I'm going to stick with what I've got, what was then outstanding?
Her filing the award.
So we're back to the same question again, which is at that point in time it could have sat forever had it not been for the language of the rules saying that at the 50, and this was within the 50 days,
That's correct.
that at the 50-day mark it would become an award.
That's correct.
One was not filed.
That's correct.
And there was nothing outstanding. There were no unaddressed motions or anything.
No.
Purely and simply, motions were addressed, 50-day rule was reached, the notice of decision became an award.
That's correct.
Thank you.
Judge Norris, you asked a question during appellant's oral argument about what rule or point of law could you point to if you were to rule in their favor. If you allowed the defendant to disregard the 50-day rule in Rule 76B, basically what you're doing is you're opening the door to all litigants to disregard timelines and deadlines as stated in the rule. And I don't know if we want to go down that path. With regard to their argument or their statements with regard to a trial on the merits, I would point to in appellant's reply brief, they stated that arbitrators are granted vast powers under Arizona's system of compulsory arbitration, having the authority to rule on almost all issues aside from dispositive motions and a handful of other motions outlined in Rule 74. They are duly appointed officers of the court and essentially act as judge and jury in nearly all matters under $50,000. We had an arbitration in this case. The facts were presented by us. They had an opportunity to present their facts, cross-examine our witness, present medical reports. Everything happened. This was a decision on the merits. Now, I understand that they're upset, maybe, bothered that they missed the deadline, but the rules are there to promote fairness. The deadlines and the timelines stated in the rules are there to promote fairness.
Is it purely an issue of equity, as counsel suggested?
Yes, I believe it is.
Okay. So if a timeline is blown, the court should look at the equity issues in deciding whether or not to extend that timeline?
If the timeline is blown, I think the court needs to look to the rules in place. And their citation to Rule 9 of the appellate rules, Rule 6 of the civil procedure rules. However, again, those rules, if you get to those rules, it's premised on them having not received notice of the order or judgment. And I don't think they can say that. I don't think they can say that they didn't receive notice that the notice of decision would become the award, because a plain reading of Rule 76B tells everybody that if the award is not filed within 50 days, that notice becomes the award. Did I answer your question?
I believe so.
Can I answer any other questions?
Thank you, counsel.
Okay, round three. Let's finish this up. First off, it's not essentially a jury. There is no jury. The One thing about the jurisdictional question, we can talk about the bad stories of the arbitrator dies or it sits forever. This is 3 days. 3 days. There are plenty of cases that talk about abandonment, and in fact, some of them are discussed in the DeCola case. We're talking about 3 days after the court-imposed pedantic deadline if we read the rule. And I'm going to sit here and say again, if you're going to read the rule and only read the rule, you're going to rule against us. I'm here to convince you that you can't just read the whole rule if we're going to have an equitable decision, if we're going to have a fair system, if we're going to have appropriately apprised due process. But one interesting thing in the DeCola case, it says the arbitrator is deprived of jurisdiction on the, quote, filing of the award, unquote, not the filing of the notice of decision plus 50 days. Now, I understand we can easily infer, well, we've converted it because that's why we're here. It magically sprang into something that if you look on the court docket, you don't know exists. You see a notice of decision and there's no court engaging in any activity that says we've now converted it to an award, even on the docket. I can't look at the docket and find the date, May 21st, on the docket to start the appeal. I could do that for a judgment. I could do that for minute entry issues. I could do that for anything else.
But to be fair, again, I don't mean to pick on you as counsel, but you can do that by getting a calendar out and counting the days from the notice of decision.
Absolutely, and that goes right back to if you're going to pedantically apply the rule, we lose. I've conceded that.
Counsel, don't we do that across the board in any number of different ways? Orders of protection. You don't get a notice that the order of protection has lapsed. On a given date, the order of protection
Well,
is
when
an
an order-
injunction that's put in place for a specific time, for a specific purpose. You don't get a notice that, okay, that purpose is no longer present and the time has lapsed. It goes away.
You know, and we can always think of examples on either side, and those are lapsed. They're no longer there. I understand that, but I'm going to come back to from the very beginning when Rogers versus Watt and Park versus Strick were done. If you take the analysis you're doing right now, those cases were all wrongly decided because we had a rule, we had notice, we should have figured it out, we could have found out, we could have looked, we could have counted, we could have added. If that's going to be applying to the lowly, nobody wants to deal with an arbitration case in the higher areas of judicial response or pontificating, fine. Then say that and we lose. I've been very clear about that. But we don't have case law that says we always read the rule, we add 50 days, we give you no notice. Oh, but let's be clear here, but before the case ever gets dismissed, ultimately you're going to get notice if you didn't go through any of these. If it sat for years, and then you came in and asked for your application for an entry of judgment 5 years from now, I guess you'd get it, wouldn't you? Because the time to appeal had run, you could get the application. But the court does say after a certain number of days, we're going to tell you that we're dismissing it because you haven't done the very tail end of the process. So from our perspective, it is a matter of equity, Judge Jones. You're dead on. It's also a matter of the legal framework that exists in our state for both constitutional and rule and fairness protections. DeCola decries exactly the time when there should be a remedy. And once again, I want to be absolutely clear. We're not going to sit here and tell you that we didn't miss the time if you just do the rule. And if that's your narrow decision, the rule is the rule is the rule, then I've wasted my breath, but I've tried valiantly. Thank you.
Thanks, counsel. All right, having heard the argument, and we do appreciate it, we're going to take the matter under advisement at this time, and we will rule in due course. Counsel, thank you for your time.